Administration and liquidation are both formal insolvency routes, but they are used for different reasons. Directors sometimes ask which one is better. A better question is, what is the process trying to achieve? Administration is usually about protection, control, and preserving value. Liquidation is usually about closure, asset realization, and winding the company down. That difference matters because the right route depends on what remains inside the business. Administration can be useful where there is still a business, asset base, workforce, contract book, brand, or sale opportunity worth protecting. An administrator is appointed and takes control of the company. A legal moratorium can protect the company from many creditor actions while options are assessed. In practical terms, administration may help where a business needs breathing space, where a sale is possible, where creditor pressure is moving quickly, or where immediate liquidation would destroy value. Liquidation is different. In a creditor's voluntary liquidation or a compulsory liquidation, the company is being wound down. Trading usually stops. A liquidator deals with assets and creditor claims, and the company moves toward dissolution. Liquidation can be the right route, where rescue is no longer realistic, where there is no viable trading core, where a sale is not likely, or where the cost and complexity of administration would not improve the outcome. So the first checkpoint is whether there is value to protect. Does the business still have contracts that could be sold? Is there goodwill? Are staff, systems, customer relationships, or stock worth preserving? Is there a buyer, funder, or realistic restructuring route? Would immediate closure destroy value? If yes, administration may be worth exploring. If no, liquidation may be more proportionate. The second checkpoint is urgency. Administration is often considered when creditor action is moving fast. A winding up petition, landlord action, or enforcement by a secured lender. Supplier pressure that threatens trading, or another formal step that could break the business before options are properly reviewed. The moratorium can matter because it creates a controlled space. But administration is not a general shield to avoid difficult decisions. It has to serve a statutory purpose. The third checkpoint is cost and complexity. Administration is usually more complex and more expensive than liquidation. It may involve trading the business, managing employees, and managing buyers. That can be worthwhile, where the value preserved is greater than the extra cost. But if the company has little value, administration may not be suitable. The fourth checkpoint is control. In administration, directors normally lose day-to-day control. In liquidation, directors' powers also largely cease. Either way, directors should prepare records, cooperate with the office holder, and understand that their decisions before the insolvency may be reviewed. The fifth checkpoint is what happens to the business, not just the company. Sometimes administration saves or sells the business, but the original company does not survive. For example, assets may be sold to a buyer while the old company dissolves. That distinction matters. Preserving jobs, contracts, or value is not the same as rescuing the existing company. Liquidation means the trading life has ended. The sixth checkpoint is director risk. Neither route automatically protects directors personally. Personal guarantees, overdrawn director loan accounts, and payment decisions still need careful review. A formal route deals with the company. It does not automatically answer every personal exposure issue. The practical documents directors should gather are similar: creditor list, HMRC arrears, payroll position, bank accounts, assets, personal guarantees, and forecasts. That pack helps professionals assess whether administration, liquidation, a CVA, or informal restructuring is realistic. A simple way to think about it is this. Administration asks, can value be protected? Liquidation asks, how should it be closed properly? Debt Decoded provides educational information and preparation tools only. It does not provide insolvency, legal, or regulated debt advice. If there is a petition threat, secured lender enforcement, or payroll risk, speak to a professional quickly. If you need more information, guidance, and tools, visit www.decoded.co.uk.